Good afternoon. I'm Mary Ellen Knack of the Attorney General's Office. I represent the Department of Revenue in this case. Pardon me. I would like to reserve 2 minutes.
2 minutes.
For rebuttal.
Okay.
The issue in this case is whether Alsco's commercial cleaning operations qualify it for the industrial machinery exemption under the state sales and use tax. It's our position that the trial court erred in reversing the department's administrative judge's determination that Alsco did not qualify for the exemption, and that the administrative judge's decision was supported by substantial and material evidence, was consistent with applicable statutes, and was not arbitrary or capricious.
And that is, under that standard, we really look at the same things that the trial court did, correct? And what the trial court did is not that significant. It's what we look at the administrative record and evaluate it on those UAPA standards.
That's correct, Your Honor. I believe it's the Presley decision that says that. Basically, this court is in the same position as the trial court and is looking at the factors under 4-5-322 of the UAPA, so it's not under Rule 13D. Briefly, Alsco is in the business of renting textiles to various types of industries, including hotels, restaurants, hospitals, any environment that may need linens or that employees may be required to wear uniforms. To perform this function, Alsco has a lot of cleaning equipment, including a boiler, washers, dryers, ironers, folders, that clean the textiles and that prepare them to be re-rented to its customers. This process uses a combination of steam, water, mechanical action, and chemical treatments to perform the cleaning. The administrative judge properly rejected Alsco's argument that it was engaged in processing, reasoning that the textiles were not transformed into a different state or form through these cleaning operations. The Sales and Use Tax Code does not define processing, and that's the term we're looking at, because I think everybody in this case agrees that that fabrication is not taking place here. The issue is whether processing is taking place. Since the code does not define that term, the Supreme Court, in its Baer decision, borrowed a definition from a body of case law that had developed in Ohio. And that definition says that processing is a transformation or conversion of materials into a different state or form from that in which they originally existed. It's the department's position that the textiles being cleaned are not being transformed into a different state or form. They're being cleaned to return them to their original condition so that they can be re-rented to Alsco's customers.
Since we being the state of Tennessee borrowed the definition of processing from Ohio, do other Ohio cases of that on that definition matter, or are they relevant?
They would be persuasive authority, but it's our position that this court is bound by the published decision in Walker's that this court issued previously, in which this court held that a company that laundered and dry cleaned formal wear was not engaged in processing under the Sales and Use Tax Code.
That's hardly the same thing as doing the things that this company is doing, is it? I mean, this is far beyond that. They have boilers and engineers there all the time worrying about temperature and insertion of chemicals and things like that. That's way beyond a laundry, isn't it?
I don't think it is, Your Honor, and I think the testimony of its own witness reveals that there are a lot more similarities between Alsco's operation and a regular cleaning operation than there are differences. It is true that Alsco's witness stated what Alsco does is much larger in scale. Its chemical processes are a lot more sophisticated, but in the end, he said, it's essentially the same as what you do when you operate your home laundry. You have the chemicals.
Well, yeah, I've got Tide that I dump in my washer, but that's hardly the same thing as being very careful about which chemical mix you put in and at what temperature it is. I just dump the stuff in and turn on the washer on, normal or whatever.
The level of sophistication is different. The scale of the operation is different. The operation being performed on the textiles is the same as what you're doing at home, believe it or not. You're using a combination of heat, water, mechanical action, and chemicals, i.e. your Tide. To the degree that your drum agitates the clothes, you're using mechanical action. You may use hot water or cold water. You're using water. You may choose to use heat. You're using the same elements that this company uses to clean these textiles to be re-rented.
Well, there's a vastly different degree, and didn't the Ohio Supreme Court say that a similar company that did similar work as this company in the Van Dyne Crotty Company versus Limbach, didn't that say that the sort of thing that this company does is processing?
Yes. Yes, I don't think I can distinguish the facts of this case from that case. But I do think that the Ohio Supreme Court was applying this statutory exemption, construing this statutory exemption in favor of the taxpayer, which is contrary to Tennessee law. Actually, it's contrary to Ohio law too, but that particular decision doesn't mention what that rule of statutory construction.
In general, there is some reference in that case, part of another issue being addressed with regard to taxation or an earlier time period with regard to reading the tax against the state, right, in terms of a different time period in the Van Dyke case, right? So there is another reference where it seems to be that it's being, at least for one of the issues in the case, it's not being read against the taxpayer, but instead against the state.
Your Honor, you may be right. I did a quick word search of using the terms that the Ohio courts normally use when they talk about the presumption.
General, in terms of the textiles here, they come in and they're soiled and they're stained, and we're talking about sterilizing. They're valueless essentially when they come in the door, right? And why isn't this processing that is essentially creating, in many respects, a product that is then usable? Because the stained, soiled ones can't be of any value, and they go through this cleaning that occurs, and they all of a sudden do have value again. Why isn't that enough to make it processing?
Well, the administrative judge agreed that the cleaning increased the value of the product.
Do they have any value, though, in their form? I mean, as sort of a soiled, contaminated rag. And does it have any value?
Well, I think they do, because Alsco buys soiled, contaminated products being shipped to them that still contain sizing and possible contaminants that were acquired in the shipping process.
Can you explain sizing a little bit? And so the product, this is before first use, right? Sizing comes into play. What exactly is sizing in this context?
Sizing can be a wax-like substance. It's applied to the cloth by the manufacturer to, so that it moves through the loom or the weaving apparatus more easily without getting snagged or caught.
Is the item usable before and I may be getting my terminology here wrong, but let's say I have a towel and it's got this wax on it. Is it usable before the wax is removed? Can I use that towel?
You wouldn't want to.
So is there...
Because it won't, I'm sorry, because it won't, it prevents absorption.
Is there a distinction then to be drawn potentially in this case between the sizing done by Alsco and the cleaning done by Alsco? Because the product comes in before the wax is removed and it's unusable. The product after it's a towel. You could use it as a towel. You wouldn't want to use it as a towel necessarily, but it's still a towel. Is there a distinction to be drawn between those two things in this case?
I can see the argument, but for practical purposes, no. So if the original manufacturer at the end of its process removed the sizing, perhaps that operation would qualify as part of its industrial machinery operations.
But that wouldn't be a high percentage of what the machines did, so it might not. Wouldn't we have to send that back to the trial court to decide?
If the court came up with an exception, if the court decided to treat those materials differently, I don't think we have the proof in the record for what percentage are they buying directly from wholesalers and what percentage are they recleaning
Yeah, there
and
would have to be
recycling
more
from its
discovery.
customers.
Okay.
With all due respect, I still do not think this can be meaningfully distinguished from a home laundry based on my previous arguments. And this comes directly from their witnesses' testimony. The test isn't how big and sophisticated their operation is. The test isn't how big their boiler is. The test is what's the degree to which these items are being transformed. And our position is
do we have to, if we decide there's material evidence that supports the ALJ's decision, even if there's other evidence that goes the other way, we have to support the ALJ's decision, right?
yes, Your Honor, but just to lay everything out, the department didn't present any witnesses. The testimony that was presented was largely undisputed.
Okay.
So I don't want to mislead the court into thinking there's some great factual dispute.
General, is this a pure legal question? I mean, is this just a de novo legal question that's before the court? What is processing and the facts are agreed upon, and do we just have a law question before us?
Well, I would like to argue that 4-5-322 actually has meaning in this context, but historically the courts have construed tax statutes on undisputed facts as using a de novo standard.
Thank you, John.
And I see my time's up. Thank you.
Thank you.
Good afternoon. May it please the court, Carolyn Wenzel on behalf of the appellee, Alsco. This court should affirm the Chancery Court holding that Alsco is entitled to industrial machinery exemption from sales and use tax under 67.6.102 and 67.6.206A. This case is about construing the plain language of the statute, interpreting Bayer, Tennessee law, and applying that construction of the industrial machinery exemption statute to the undisputed facts that what Alsco does is carry out an operation in a series of activities and steps, which is a process that results in a marketable product in the form of a hygienic, one-time use textile. The only issue is whether using the common ordinary meaning of processing applied to Alsco's undisputed facts is indeed what Alsco does and thus results in qualification for the industrial machinery exemption under TCA 676-206. This court should affirm Chancellor Lyle's decision for 3 reasons. It's a 3-step process. First, did the Chancery Court apply the correct standard of review? Second, this court applies that same standard, which is found, as General Knack mentioned, in the Administrative Procedures Act, TCA 4-5-322H. This court applies that same standard where the findings of fact are undisputed and given a presumption of correctness. The questions of law are de novo and twofold. What does the statute mean, and how does that statute's meaning, how is it applied to the facts? That's step 2. And then step 3, the third reason, I should say, that this court should affirm the Chancery Court is that Alsco's case is consistent with Tennessee law, both the plain meaning of the statute and Baer, the controlling case, which even Walker's, which General Knack mentioned, relies on Baer as the law in Tennessee for the definition of processing.
Counsel, I'm struggling to see it. Maybe I'm looking at it a little bit different than Judge Bennett, but how this is different than Walker. And I can put a lot of fancy scientific language explaining how I get soap or oil off of my hand. And we can talk about chemical reactions and processes and bonding. And we can do the same thing with a washing machine. My home washing machine has an impressive number of cycles these days. But it seems to me that there's not and in scale there's a difference, but conceptually isn't this the same thing as the home washing machine or just candidly soap, just at a much more sophisticated level?
I appreciate that, Judge Usman, and I appreciate that Walker's, one would be drawn to Walker's because it involves cleaning, and Alsco is an industrial cleaner producing one-time use textiles. 2 important facts that allow Walker's to stand but not be controlling. One is, we don't know what the facts were in Walker's. In fact, if we look at the Walker's opinion and what this court said, and this is important, so I'll quote it directly. We find nothing in the appellate record that laundering and dry cleaning resulted in a change in state or form. It wasn't that out of this great big record, the Walker's company didn't prove that it was transforming and converting. What the court said was, we find nothing in the appellate record. And so that alone is a difference, a huge difference, in that we have a large record here. We have a very detailed record. We have 3 witnesses, including an expert witness, who detail, and this brings us back to the other reason why Walker's is distinguishable. Those witnesses detail the steps and operations that Alsco conducts, those activities that Alsco conducts in its industrial facilities that result in a change in state or form to the items that they are placing that activity on.
It was a towel when it came in, and it's a towel when it goes out. And isn't that the same thing? It's now a clean towel, but it is what it was. And they haven't created a new product or even a different product than what it initially was. It's still a towel, isn't it?
Thank you. That is an important point in the administrative law judge's decision. The administrative law judge references new product, That's not the standard. The standard is to construe processing as it exists in the statute in Tennessee, in 67.6.102. And processing, the complete phrase is processing tangible personal property for resale. And that phrase, if we look to the plain meaning as, back to the point of this is a de novo review, correct? So this court sits, just as the trial judge did, in a de novo review in statutory construction. So the first step is to look at the plain and common meaning of processing. Well, the dictionary definition of processing, there are several, a series of actions, changes, or functions bringing about a result. A series of operations performed in the making or treatment of a product. To prepare, treat, or convert by subjecting to a special process. On top of that plain meaning of processing, we have Bayer, which, as this court referenced while General Knack was speaking, relied on Ohio law interpreting the word processing. And so, coming back to, it's a towel before and it's a towel after. In Bayer, it was food before and it was food after. Processing is the activity incident to transforming or converting state or form into a marketable product. What is it here? A towel before and a towel after, that underlying character.
The Ohio Supreme Court in the Van Dyke decision, to have that right?
Yes, Your Honor.
So the Van Dyke decision, if I recall correctly, the Ohio Supreme Court is not applying any type of adverse presumption against the taxpayer in that case, or there's no reference to it. I do believe there's a reference to a presumption in that case with regard to another matter that's actually favorable to the taxpayer. Isn't that enough to distinguish the Ohio Supreme Court? Don't we have to apply an adverse presumption because of the nature of the exemption or exception in this case against the taxpayer? So if it's a close call, doesn't it lean to the state here?
I submit to you that it is not a close call, and a couple of reasons why. The record, the facts are undisputed. And so we give a presumption of correction to the facts that are in the record at the administrative level. But the question of statutory interpretation and the application of that statutory meaning to the facts are both questions of law. To the point of the burden, yes, Tennessee law is that exemptions in Tennessee are construed against the taxpayer. We had the burden at the administrative level. We carried the burden at the administrative level. We put on a record full of facts about the changes in state or form, and that the activities that Alsco does make changes in state or form that result in a marketable product. What are those changes in state or form? An unusable product into a usable product, a completely unabsorbent towel into an absorbent towel, a contaminated and unsanitary napkin that is converted into a hygienically clean, certified by an accrediting agency that can be placed on a table for a new customer to pick up and place on their mouth. Those are the changes in state or form that Alsco does in its activities incident to creating those marketable products. And that's the standard under the Ohio statute, under the Ohio case, Van Dyne-Crotty, as well as Gressel, that was then adopted by Bayer, and again, adopted by Walkers. But Walkers didn't have a record.
If the court adopts your approach, and let's say we get there's the next dry cleaner case that comes up, don't dry cleaners also have to qualify for this same processing rationale? I bring in my clothes, they're soiled, I can't wear my suit that's covered in whatever it's covered in, and it becomes more value or becomes valuable through the cleaning process. And don't those two have to go together, and your client and dry cleaners?
Yes and no, Your Honor. This case, this court is reviewing de novo application of the law to the facts in this case. That's the standard under 322H. Walker's didn't say that dry cleaning is never processing. What Walker said is, we find nothing in the record that reflects dry cleaning and laundering as converting state or form. So I don't know what the record is on the next dry cleaning case, if there is one. One aside here, what Walker's was in dispute about was qualifying what it did as a sale for resale. This is not a sale for resale case. In fact, sale for resale doesn't use the word processing in the statutory scheme. This is an industrial machinery exemption. And the industrial machinery exemption statute includes the word processing many times in the statute. In fact, if you get to the department's rule about the industrial machinery exemption and the application, the process that one goes through, procedure that one goes through to apply, it doesn't include the word processing. The word processing is found in the statute. And this court, like the trial court, is reviewing de novo the statutory language, and like the trial court, is reviewing the undisputed record and applying the law de novo to those facts. Chancellor Lyle found that the decision of the administrative law judge was unsupported by material and substantial evidence in the record. And the administrative law judge's application of the statute to the undisputed facts was incorrect and against statutory authority. And it's for those same two reasons that this court reverses the administrative law judge, in effect upholds Chancellor Lyle's decision, which reverses the revocation of Alsco's industrial machinery exemption certificates, which the department had granted to Alsco, but then revoked. And so thus, the relief as awarded by the Chancery Court, and which I submit this court should award, is the reinstatement of Alsco's industrial machinery exemption certificates that were granted in April of 2019. Thank you.
Thank you. General Mack?
Processing requires that the product actually be transformed or converted. It's our position that the terms transformed or converted suggest either a new product or a change in product. Returning an item to its original state in which it was leased to a customer does not qualify as a transformation or conversion.
Well, you did say returning. Doesn't that give some notion of change back?
It's our position that they're renting the same products over and over and over, and that they're merely cleaning them in between, and that cleaning is not processing. The taxpayer could have contrasted the facts of its case below with an ordinary laundering and dry cleaning business. It did not. Instead, it put on a witness that likened the operation, although on a very large, sophisticated scale, likened their operation to a home laundry business. Again, it's our position that the trial court construed the statutory exemption in the taxpayer's favor in violation of well-established rules of statutory construction, we ask the court to reverse the trial court's decision and to reinstate the administrative judge's decision. Thank you.
Thank you both. We appreciate your arguments. Would you call the next case, please?